All right, hi, and welcome back. Attorney Steve Vondran. Hope you guys are having a great Wednesday. I wanted to kickstart this Wednesday with a new video called My Kid Did It. This is a series from my litigation whiteboard, and I want to talk about what happens when your kids do something online, like download movies, copyright infringement, in particular copyright infringement, download movies or software, things that are not photos, books, things that are not licensed to use. And what could possibly happen? Could the parents be held liable? Without further ado, let's head to the Attorney Steve Litigation Whiteboard. Okay, here we go. We're back. So the question in this video is, what happens? Your kids do the download. Now what happens? Say we're talking about strike 3 movies. This is a big one. Adult pornography movies being shared on through applications like the BitTorrent application, uTorrent. And your kids might be sitting at home. We have a lot of kids now. Here's my picture. We got our kids right here. A lot of kids are home now. They're coming back from college, looking for work. Of course, that's presenting a challenge now when you can't go out into the marketplace and things like that. But we have kids moving home. We have young kids at home, 15, 16, 17-year-olds going to high school, college. You guys know what it's like. You know what happens in college. Everybody knows in high school. You know, kids are kids, and kids are going to do their thing. And now kids don't always even know what's going on. Like their kids don't go out and say, I'm going to violate the copyright laws. Some do, some don't. But it's not like something they teach in high school. You know, what is copyright infringement? I think some people know and they see the big screen when they go to the movies, but when you're on the internet, you don't see that big FBI signal. You don't see the big warning telling you, hey, you know, don't record this broadcast or whatnot. So on the online world, you don't really see any big FBI disclaimers. That's supposed to be a C, copyright, but you know, so your kids might be here downloading books, movies, software, things like that without a license, okay? And so remember Napster. Everybody remembers Napster, and Kazaa is an application. So, but the question here really becomes in these cases when I get a letter and the parents call me up and they say, what can I do? I got a letter from Strike 3 and I didn't do it. I'm the subscriber. I'm the parents. I'm the subscriber, but we didn't download the movies. It was my kid. You know, my kid's 16. What do we do now? Can we settle? Can they sue him? Well, the general rule in tort law, what we call torts, personal injuries, wrongs committed by one person against another. In this case, we are talking about injuries to intellectual property, injuries to intellectual property. And the general rule is a kid and even the insane can be held liable for their torts. Children and the insane can be held liable for their torts, okay? Somebody's got to pay, right? If your kid did it, somebody's got to pay. And that's the general rule. Now, there's exceptions and all kinds of rules. This is not legal advice. This is general legal information only. Let's just bear that in mind, so I'm not giving you any specific questions. In fact, I'm going to be talking a little bit about California law here, okay? So there's all kinds of rules and exceptions, this, that, and the other. But generally, the kids can be held liable for their torts. Plaintiffs can sue kids and minors for, you know, willful, malicious torts, okay? So here we have it. So you have your kid. Now, the question in these cases becomes, can we hold the parents liable for what the kid did? That's what we're talking about in this video. Can you hold the parents liable for what the kid did? There are two theories. There are two theories of liability. Now, I want you just to be clear on this. First, we have direct liability. That's against the kid, okay? So a plaintiff can always go right after the kid, sue the kid and say, well, I'm a minor under 18. Yeah, well, you know, you committed a tort, okay? So, but in practical reality, I think we had the music company, RIAA, was out trying to sue some people and everything. It got real hairy. But you don't see a lot of this, but it's not as if it couldn't happen. So it has to be something that you bear in mind. If you get a letter from someone like Strike 3, you say, well, you know, maybe I'll end up being sued. Could that ruin my future? Can we make sure everything is filed under seal so that nothing comes out here? Those kinds of things. So a lot of times these will turn into settlements. But so you have the kid, direct liability, number one. See it in red? Number two, indirect liability. Okay, so that's what we're talking about. Now, real quick, I have here, I'm going to check the box, parental, joint, and several. I put a box around that. That's your buzzword for the day for my bar students. Joint and severally liable. What does that mean? It means both are liable, joint and severally liable. One of y'all's has to pay, as one of my associate attorneys used to say. One of y'all's has to pay. So, but there you have it, joint and several liability. Let's check the box. Real quick, I want to touch on California Civil Code section 1714.1. Let's talk about that real quick. General information only. This is the law that says parents can be held jointly and severally liable, okay, in California. Now, every state's going to be different. You're going to have your own laws, check your own rules. But California has 17.14.1. There becomes a question. There is a cap. There's a cap put on the parent's liability, $225,000 per tort, I believe it's worded, $25,000 per tort. Then the question becomes, well, when you download 40, 50 movies, is that one tort? Or is that like 50 torts? There's 50 movies. Is that 50 torts? Because then that cap wouldn't really help you out much, would it? So there is a case called the Kessler case. It says a series of ongoing infringements that could be considered as just one infringement. So the $25,000 cap would apply. There's the Thrifty Tell case. That was a case on point for holding the parents jointly and severally liable for their sons, their kids and their friends' phone hacking. They were hacking the phone service to try to get free phone calls, okay? So there is here's two cases on point. Now, I want to point out, so you know just in general that law is out there. But I want to talk about preemption. Preemption. Now, copyright is a federal law, okay? This is a state law. This is a civil code, California Civil Code. That's a state law, okay, enacted by the state legislature. Copyright law is a federal law, as I have here. This is enacted by Congress, and it's a federal law. And there is a question here. I have section 301. Will this preempt, in a case where you're dealing with parents and kids, will this preempt the state law? Will this preempt the state law? So that is one question that could pop up in a case where the kids they're looking to go after the kid. But just bear that in mind. We have a Capitol Records case, another case on point in this area if you want to do some research. That was a case where they had a CASA installed on I believe it was a family computer. It may have been in the kitchen, I'm not sure, but there was a family computer. And they tried to hold the parents liable for that. And the court, you can read it yourself. Capitol Records v. Foster said no. So no on that. So that may be a very helpful case if you're in federal court and you have to cite to something. That could be very helpful. Now let's go back to this and close this video out here. So we're talking up here. Now, so you have all that. Good. We just went through all that, okay? You got this. You got direct liability. And the second option is the joint and several liability. Let's circle that right here. This is what we're talking about, okay? So you have indirect infringement. This is direct liability, direct infringement. This is what the kid did. That's the direct infringer. The question is, can you hold these people liable, the parents or the guardians, let's say, for not stopping this, for helping it, for contributing to promoting it, to turning a blind eye, those kinds of things. Can you hold them liable? So you have indirect. This is, let's go A, vicarious liability. Vicarious liability can be shown if a plaintiff can show that the parent had the right of control, ROC, the right of control, and a financial interest in the infringement. So in other words, if you were like, hey son, go ahead and download, and why pay the $20 a month? Why pay the $20, whatever it is? I don't know what it is. Why pay the subscription fee? Just go get it. It's all, nobody's gonna know. That could be vicarious. Right of control, financial interest, that could be vicarious, okay? So just be thinking about that. So if you're a parent and you did that, then maybe you could be held jointly and severally liable, okay? The second one is contributory inducement. This is what it says. You're contributing, you're participating, you're knowingly, voluntarily acting in a way that's helping somebody infringe, okay? Or you're helping induce infringement. is another one. So, these pop up where let's say you shoot your kid a thumb drive and you say, hey, I know you're into video editing. Here's some free video editing software, kid. Have fun. Final Cut Pro. Everybody wants that, right? Final Cut Pro. There it is. Have some fun with it, kid. No big deal. Present from your uncle. So anyway, so this is contributory, knowing participation, those kinds of things. So in a case, if you get a letter from Strike 3, or nowadays you also see these, what they call the Bill of Discovery in Miami-Dade County, Florida, where Strike 3 Holdings is suing companies, I would say, filing bills of discovery in Florida is probably the best way to say it. But these are theories that you have to look at if you have kids, and there are times when kids do it. So the question is, do you want to settle your case? Do you want to take a chance that the kid gets sued? Where you have to make very sure you're sealing records and things like that and applying to the court to seal records. But that's it. That's copyright infringement. You got your direct, your indirect infringement, your two theories, some of your state law, question about possible preemption, and some case law there to guide your thing. So if you need help with an internet infringement case, we can help. Give us a ring. There are very few firms in California. I think we're at the top as far as number of cases handled in the area of internet file sharing. So find us on the web at attorneysteve.com. That's attorneysteve.com. The first name in legal services. Go out and have a great day. Enjoy your Wednesday. Be nice to people. Come on. We're going to get through this. Be nice to people, okay? Have a great day. attorneysteve.com. Bye now.